let me welcome you to the conversation segment on the Signature Show this Sunday afternoon. It's good to have you on.
Thank you so much.
All right, so sir, Inec has consistently been saying that politicians should not receive money from abroad as part of funding their election. Is this position supported by the Constitution and the Electoral Act?
Oh, definitely. You know that the Constitution of the Federal Republic of Nigeria, 1999, as amended, as well as the Electoral Act 2022, and our regulations and guidelines are the constitutive legal instruments for the conduct of election. Now, Section 225 of the Constitution of the Federal Republic of Nigeria, which is the ground norm of the Federal Republic of Nigeria, which is the fundamental law, makes it imperative that one, that no political party registered in Nigeria shall maintain a foreign account. Secondly, it makes it clear that no registered political party shall also receive funds from outside the country. And that if any of them receive such funds from outside the country, that they must turn in such funds to the Independent National Electoral Commission within a period of 21 days of the receipt. So the Constitution, which is the fundamental law of the land, makes it imperative that they cannot receive funds from outside the country and that they cannot maintain foreign accounts so long as they remain political parties registered by the Independent National Electoral Commission.
So what is the punishment for fouling this law?
You know, the political parties are registered by the commission. They have the incidence of registration. Now, by Section 225A of the same Constitution, a political party can be deregistered for failure to keep to the tenets and intent of its registration. So political parties are aware of this, that it is not right and that it is unconstitutional to violate the fundamental law of the land. Secondly, if you also look at the Electoral Act, it also makes it clear that any political party that violates any of the provisions of the Constitution relating to maintenance of foreign accounts and so on can be proceeded against. If it's an individual that has violated the law, the person will face sanctions under the law. And if it's a political party, that same political party will also face sanctions and also lose whatever funds we are remitted to it from outside the country.
Okay, so the Constitution seems to focus on the political parties and not the individual candidates. Is there no difference between a political party and individual political candidates?
Well, individuals do not contest elections in Nigeria in the real sense of the word. If you look at the Constitution, it says before a candidate can be on the ballot, the candidate must belong to a political party and sponsored by that particular political party. So the candidates are subject to the political parties. So whatever a candidate does also revolves around the political party and also reverberates around the political party. And so no candidate is supposed to also receive funds from outside the country, because if you leave the door open, the implication is that a candidate may go and receive funds from an organization that is engaged in terrorism, or an organization that is focused on terrorism. They can also go and receive funds from countries that are hostile to the Federal Republic of Nigeria, and that is why the makers of the law and the Constitution made it specific that such will not happen, and that the focus should be on political parties and not necessarily the candidates.
Okay. So apart from the letters of the Constitution and the Electoral Act, what is the intent of this law barring political parties?
I think that the intent is that political parties must be political parties of the Nigerian people, that there must be political parties funded by the Nigerian people, and that there must be political parties focused on the Nigerian people. If you also look at a section relating to the registration of political parties from section 221 going forward, it makes it very clear that all the political parties must subscribe to the fundamental objectives and directive principles of state policy, which focuses on the political objectives of the Federal Republic of Nigeria and not subject to the dictates and the directions of hostile powers or foreign countries or other countries that do not mean well for the Federal Republic of Nigeria, or even other organizations that engage in terrorism, or organizations that are doing things that are not in consonance with the fundamental objectives and directive principles of state policy.
Does contribution from individual Nigerians, wherever they may live, supporting individual candidates with funds undermine the intent of this law?
The position of the law is very clear. So long as you are outside the confines and jurisdiction of the Federal Republic of Nigeria, you are in diaspora, you are outside the country. If you are in Chad, if you are in Benin Republic, if you are in Sudan, if you are in Cameroon, it is the same thing. It does not matter that you are in Chad and you are not in the US. It does not matter that you are in Sudan and you are not in Germany. It does not matter that you are in Cameroon and you are not in Italy. The intent of the law is still the same thing. You are outside the shores of the Federal Republic of Nigeria. And the law and the Constitution says that you should not receive foreign funding. And that if you receive foreign funding, you must turn such funds to the Independent National Electoral Commission. Not only that, the law also says that you cannot receive funds that you don't know the source. In other words, you cannot receive anonymous donations. And if you receive anonymous donations, you must turn them into the commission. The importance of this is that at the end of the day, auditors are supposed to audit your accounts. And after auditing those accounts must be made available to the commission to also scrutinize and also laid before the National Assembly. And if any auditor assists any political party to falsify his books of accounts, the penalty is very, very severe. And if you have received money from a source you cannot account for, it will be in your audited accounts, and the commission can proceed against you, because in that circumstance you have fallen short of the provisions of the law, and you can be proceeded against.
Now, the law seems to prevent sovereign or corporate organizations from influencing or undermining our national security.
The law is also very, very clear that even if a corporate organization or a corporate entity or an individual wants to donate to your political party or wants to donate to your account as a candidate, you must be very sure that you know the source of that particular money. If you are not sure of the source of that particular money, you are not supposed to touch it, because if there's a possibility that the individual or the corporate entity wants to use the political party or the candidate as a means for money laundering, so such under the law is not allowed. So the law has pegged the amount of money a corporate organization can donate to a political party or to a candidate to I think 50 million and not more.
There are two issues. The Constitution is barring political parties from receiving money abroad and not the candidates. Because if I, Marvelous Obama, wants to contest for an election, and I have friends outside Nigeria who are wealthy, who wants to support my ambition to becoming a governor, I mean, what stops them from supporting me? That is one. Two, if the Constitution is barring political parties from receiving money abroad, why did the Constitution also make opening to say that if the INEC finds out that political parties receive money abroad, they are supposed to remit that money within 21 days? And the Constitution did not make it clear what INEC does with that fund if so receives in the next 21 days. Please, can you clear some of these issues?
The accounts of political parties may be accounts that are in the public domain. And I give you an example. For instance, when political parties are conducting their primaries, sometimes they require candidates to buy forms. And when these candidates go to buy forms, they buy forms from the banks and make remittances to the banks, in which case the individuals who are contesting for various positions have the account number of the various political parties. So if they have the account number of various political parties, there is no way a political party can prevent funds from going into that account. What is important, and that is why the law is very clear, that if you did not authorize anybody to pay money from outside the country into your account, the moment you see it, you must remit that funds back to the, you must remit those funds to the commission. Moreover, you know that the commission charges political parties monies for administrative purposes, and the law also permits the commission to return funds that it cannot spend at the moment and open a separate account for it. So the commission is a public trust, it's a public institution that is also revenue generating in a sense. So the commission can return such funds and also apply those funds for the purposes of executing any of his programs and policies. And when it's time for appropriation, the commission can also declare those funds and get it appropriated for the purposes of some of his activities. And let me also be very clear. We don't have independent candidature in the Federal Republic of Nigeria within our constitutional framework. What we have are persons who belong to political parties and sponsored by those political parties. So the candidate is the candidate of the party. You cannot get into the ballot without the signature of a political party, without a political party sponsoring you. And the Constitution has also made it very clear that if you're a presidential candidate, you cannot spend more than 5 billion. And that 5 billion naira must be within must be spent within the confines of the Federal Republic of Nigeria and in Nigerian currency. You are not permitted to receive funds from abroad because you can never vouch for the intendment and source of that particular fund. And I'm sure the Constitution does not want anybody to use any political party or any political party platform or any political party pathway for purposes of money laundering. And you also know that it is not only the Constitution that deals with the issue of currency. There's the central bank that deals with the issue of currency. There's the Money Laundering Act and all other laws. Political parties are also, and individuals are also subject to these laws. And so we should not open the window to anybody to undermine the sovereignty of this country, or to also undermine our political process and also undermine our political parties.
Thank you so much, Mr. Festus Okoye, for being a part of the program. Thank you so much.
Thank you so much.